I thank the gentleman, and I now yield to the distinguished Vice Chairman of the Constitutional Subcommittee, Mr. DeSantis.
Thank you, Mr. Chairman. Thank you for the witnesses for your testimony. Mr. Tebby, if I understand you correctly, your objection to Hobby Lobby was that the price of giving Hobby Lobby an exemption from the regulatory mandate was that the employees of Hobby Lobby were made worse off as a result?
That's right, and I think the Supreme Court didn't do enough in its opinion to make sure that wouldn't happen.
But here's the problem I have with that point is that wouldn't the outcome have been, if that regulatory edict was upheld, that Hobby Lobby, per the advice of Justice Kagan and Sotomayor during the early arguments, Hobby Lobby would have simply gotten out of the health insurance business, perhaps, and ended up paying the tax, which Justice Kagan correctly pointed out was actually cheaper than offering the insurance. So Hobby Lobby still would have maintained its religious commitment. Those employees would have ended up in exchanges, which would have been more costly and given them actually worse coverage in many respects. So wouldn't they have been made worse off had the case gone the other way?
Yeah, that's an interesting point, and I want to acknowledge Professor Marty Lederman, who started to raise that argument, that Hobby Lobby could simply get out of the business if it didn't want to be burdened of providing health insurance at all. Unfortunately, that argument was raised late in the litigation, and there was not a record on how much it would actually cost. So whether that
well, let's just assume that the tax penalty for not providing insurance is substantially cheaper, and obviously Hobby Lobby would be in a position where they wouldn't be complicit in something that violates their conscience. I think it's questionable whether the employees I think they would have been a lot worse off under that situation. Let me ask you this, though. I'm trying to figure out kind of where the boundaries are here. In terms of how you understand religious liberty, could Congress enact a statute to require churches, like a Catholic parish, to pay for late-term abortions for its employees?
I think that would be a difficult question. I'm not prepared to answer right now.
But I mean, if under the analysis I think that you're proposing, if that parish were to go and ask for, hey, RFRA, this is a burden on my faith, not least restrictive means, under your analysis, those employees who happen to work for that parish would be worse off because they would not be getting a regulatory benefit, or maybe even Congress would do a statutory benefit. And so wouldn't you have to then say that regulation would have to be imposed on the church?
I see where you're going with this. No. And I believe
why?
The reason is because churches and their relationships with their employees are a special case, and the Supreme Court has recognized.
Okay, what about the Catholic Charities? So this is a big organization. It's not a church. It's based on Catholic principles. Would that mandate apply to Catholic Charities? Would they have to fund late-term abortion coverage for their employees?
I'm reluctant to speak on that question because I haven't thought it through carefully enough. But I do think that Catholic Charities would be required by general laws, for example, to provide adoption services to all couples in.
Well, that's a so. What do you think, Mr. Baylor? I mean, in this situation, under that analysis, well, let's even go further, more into the commercial realm. EWTN, Catholic Station, it's commercial, but clearly they have a religious mission that's core. Would that analysis mean that EWTN would have to provide the late-term abortion coverage, which is obviously something that the people who are participating, running that organization, very much would disagree with?
I think it does, and that's really disturbing about some of these arguments that are being made about Hobby Lobby. Is, you know, we tend to think it's about contraceptive, but actually the objection that was made by Hobby Lobby and by Conestoga and by many of the over 300 plaintiffs that have challenged the mandate is that they don't want to facilitate access to abortion. And this hypothetical that you've spun out is not a hypothetical. It's a reality. The District of Columbia now has adopted a law that will require all employers, including the Catholic Archdiocese, including Catholic University, including Alliance Defending Freedom, to pay for all abortions elective. California has done the same thing. So we need protection from
Let me, because my time's about to expire, there's sometimes distinctions drawn between a corporate actor or a commercial actor versus not. I mean, I think if you had a sole proprietor who was an Orthodox, running an Orthodox Jewish deli, there would be religious protections for that sole proprietor. I mean, do people dispute that? And if they don't, then simply the fact that he decides to incorporate his business, he would essentially be forfeiting his right to run his business as a real. I'm trying to figure out where this would go. So can you speak to that issue?
Well, there was a lot of difficult line drawing that folks on the other side of the Hobby Lobby case were trying to engage in during that litigation. And it was pointed out that corporations, I think everyone agrees that at least some corporations have religious liberty. Many churches are incorporated. The Christian school that my daughters go to is incorporated. So you can't say that all corporations don't have religious liberty. And then you have this prospect, as you talked about, as sole proprietorships. And is it really the case that we're going to say that someone who incorporates or has a sole proprietorship as a kosher deli can be forced by the government to do things that violate their religious convictions? The lines just don't hold up. We should keep it as it is. There was an amicus brief in Hobby Lobby that explained that when RLUIPA, the predecessor statute, was considered, Congress understood that RFRA protected commercial entities. They tried to change that and failed.
Thank you. My time's expired.
And I thank the gentleman, and I now recognize Mr. Nadler from New York for 5 minutes.
I thank the chairman. I want to go into a little of the history here, first of all. I was one of the leaders in the fight for RFRA back in 1993, and along with